Chapter 8. Unenforceable contracts. Article 1403. The following contracts are unenforceable, unless they are ratified. 1. Those entered into in the name of another person by one who has been given no authority or legal representation, or who has acted beyond his powers. 2. Those that do not comply with the statute of frauds as set forth in this number. In the following cases an agreement hereafter made shall be unenforceable by action, unless the same, or some note or memorandum, thereof, be in writing, and subscribed by the party charged, or by his agent. Evidence, therefore, of the agreement cannot be received without the writing, or a secondary evidence of its contents. A. An agreement that by its terms is not to be performed within a year from the making thereof. B. A special promise to answer for the debt, default, or miscarriage of another. C. An agreement made in consideration of marriage, other than a mutual promise to marry. D. An agreement for the sale of goods, chattels or things in action, at a price not less than 500 pesos, unless the buyer accept and receive part of such goods and chattels, or the evidences, or some of them, of such things in action, or pay at the time some part of the purchase money. But when a sale is made by auction and entry is made by the auctioneer in his sales book, at the time of the sale, of the amount and kind of property sold, terms of sale, price, names of the purchasers and person on whose account the sale is made, it is a sufficient memorandum. E. An agreement for the leasing for a longer period than 1 year, or for the sale of real property or of an interest therein. F. A representation as to the credit of a third person. 3. Those where both parties are incapable of giving consent to a contract. Article 1404. Unauthorized contracts are governed by Article 1317 and the principles of agency in Title X of this book. Article 1405. Contracts infringing the statute of frauds, referred to in Number 2 of Article 1403, are ratified by the failure to object to the presentation of oral evidence to prove the same, or by the acceptance of benefits under them. Article 1406. When a contract is enforceable under the statute of frauds, and a public document is necessary for its registration in the Registry of Deeds, the parties may avail themselves of the right under Article 1357. Article 1407. In a contract where both parties are incapable of giving consent, express or implied ratification by the parent, or guardian, as the case may be, of one of the contracting parties shall give the contract the same effect as if only one of them were incapacitated. If ratification is made by the parents or guardians, as the case may be, of both contracting parties, the contract shall be validated from the inception. Article 1408. Unenforceable contracts cannot be assailed by third persons. Chapter 9. Void or inexistent contracts. Article 1409. The following contracts are inexistent and void from the beginning. 1. Those whose cause, object or purpose is contrary to law, morals, good customs, public order or public policy. 2. Those which are absolutely simulated or fictitious. 3. Those whose cause or object did not exist at the time of the transaction. 4. Those whose object is outside the commerce of men. 5. Those which contemplate an impossible service. 6. Those where the intention of the parties relative to the principal object of the contract cannot be ascertained. 7. Those expressly prohibited or declared void by law. These contracts cannot be ratified. Neither can the right to set up the defense of illegality be waived. Article 1410. The action or defense for the declaration of the inexistence of a contract does not prescribe. Article 1411. When the nullity proceeds from the illegality of the cause or object of the contract, and the act constitutes a criminal offense, both parties being in pari delicto, they shall have no action against each other, and both shall be prosecuted. Moreover, the provisions of the Penal Code relative to the disposal of effects or instruments of a crime shall be applicable to the things or the price of the contract. This rule shall be applicable when only one of the parties is guilty, but the innocent one may claim what he has given, and shall not be bound to comply with his promise. Article 1412. If the act in which the unlawful or forbidden cause consists does not constitute a criminal offense, the following rules shall be observed. 1. When the fault is on the part of both contracting parties, neither may recover what he has given by virtue of the contract, or demand the performance of the other's undertaking. 2. when only one of the contracting parties is at fault, he cannot recover what he has given by reason of the contract, or ask for the fulfillment of what has been promised him. The other, who is not at fault, may demand the return of what he has given without any obligation to comply with his promise. Article 1413. Interest paid in excess of the interest allowed by the usury laws may be recovered by the debtor, with interest thereon from the date of the payment. Article 1414. When money is paid or property delivered for an illegal purpose, the contract may be repudiated by one of the parties before the purpose has been accomplished, or before any damage has been caused to a third person. In such case, the courts may, if the public interest will thus be subserved, allow the party repudiating the contract to recover the money or property. Article 1415. Where one of the parties to an illegal contract is incapable of giving consent, the courts may, if the interest of justice so demands, allow recovery of money or property delivered by the incapacitated person. Article 1416. When the agreement is not illegal per se but is merely prohibited, and the prohibition by the law is designed for the protection of the plaintiff, he may, if public policy is thereby enhanced, recover what he has paid or delivered. Article 1417. When the price of any article or commodity is determined by statute, or by authority of law, any person paying any amount in excess of the maximum price allowed may recover such excess. Article 1418. When the law fixes, or authorizes the fixing of the maximum number of hours of labor, and a contract is entered into whereby a laborer undertakes to work longer than the maximum thus fixed, he may demand additional compensation for service rendered beyond the time limit. Article 1419. When the law sets, or authorizes the setting of a minimum wage for laborers, and a contract is agreed upon by which a laborer accepts a lower wage, he shall be entitled to recover the deficiency. Article 1420. In case of a divisible contract, if the illegal terms can be separated from the legal ones, the latter may be enforced. Article 1421. The defense of illegality of contract is not available to third persons whose interests are not directly affected. Article 1422. A contract which is the direct result of a previous illegal contract, is also void and inexistent.